difficult to explain to clients when something goes wrong that is not our fault. While neither side should necessarily ascribe blame to the other, we have significant issues, especially lately, with non family lawyers and sloppy lawyering on the other side. While we do not name names, this is professionalism, and we do not wish to violate any sense of confidentiality or identify any one case in particular. We seem to be having some issues recently with very poor work being done on the other side. Let me give you an example. If somebody files an answer in a case and then a certain amount of time elapses, if somebody files a new answer and counter petition, or even just a counter petition as an add on months after the fact, they are supposed to, by rule, file a motion for leave to amend and attach the amended pleading, mission of us, the other side, or they're supposed to have a hearing with the court in which they ask for leave to amend and have an order granting leave to amend to officially activate the answer period for us, the other side. Unfortunately, not every lawyer checks the rules. Not every lawyer abides by the rules. Not every lawyer cares about the rules. And this can lead to sloppy lawyering. Sloppy lawyering can lead to a situation where our client or anyone else's client might end up paying extra fees because of the poor lawyering on the other side. Here's another example. If somebody has documents due within 30 or 45 days, and we're at the 45-day mark, the other side is unresponsive, sometimes we might send over a joint stipulation to them or even offer an extension to avoid our client incurring any costs for a motion to compel mandatory disclosures or compliance with another discovery request. Unfortunately, more often than not, that goes ignored, or the other side will then say, if it wasn't for those meddling kids like this is Scooby Doo, this never would have happened. Well, guess what? You have obligations. We have deadlines. We have timelines. There are court rules. The longer the other side delays unnecessarily for no good reason whatsoever, other than perhaps they cannot have good client control, or maybe they missed a deadline or forgot about it, or just didn't redact the documents or never sent them, this creates problems. The kinds of problems that are costly to both sides in a case and are frankly not easily excused, but it happens very often. Family law and divorce cases are about financial disclosures. If those financial disclosures are not provided and we have to move mountains with subpoenas and motions to compel and requests for production and maybe even depositions of certain employers and certain other parties, that's highly problematic. That's the sort of thing that I don't believe should be avoided. I think it should be complied with fairly easily, pending any legitimate objections. And recently we received objections that said that something wasn't reasonably calculated to lead to the discovery of admissible evidence. Well, that's really bizarre because that's the entire standard of why you ask anything, because it is intended to lead to the discovery of evidence to be used at trial. That's the entire reason you send out a subpoena, a request for production of documents, a request for admissions, interrogatories. That's the entire foundation of family law. Without having that leeway to ask the certain questions, ask the right questions, derive answers, request admissions to those particular answers or denials of those particular answers, and without obtaining information that directly applies to alimony and child support, what are we even doing? So an objection like that is not only foolish and misguided, it's completely irrelevant, immaterial, and it has no business being put in something other than from sloppiness and a lack of understanding and a lack of knowledge of family law. Let's take another example, another hypothetical example. Suppose that a party is defaulted and that the other side on that default claims that it was because of a calendaring issue or claims it was because they had to step out of the office or some such thing. Once you've been defaulted, there's no obligation on our side, if we're the party getting the default against the other side, to simply set it aside for no reason. If the other side delayed the case, didn't meaningfully participate in the case, and didn't have any interest in complying with the rules, why would anybody from the opposing counsel to the court excuse that sort of neglect, sloppiness, and failure to represent your client appropriately? My greater point here is that sloppy lawyering, negligent lawyering, and inattention to detail can hurt cases, can hurt parties, can lead to increased expenses, delays of time that should not happen. And what is the remedy? The remedy is that people should read the rules. They should know something about family law practice rather than just doing whatever comes to mind. Recently, somebody sent an email claiming to the actual court judicial assistant, somebody sent an email claiming that we did not contact them about an extension to discovery. Well, that's really astonishing. Not only did we contact them, we offered them an extension. They didn't get back to us. We wrote a joint stipulation on their behalf, sent it to them, they never responded, and then lied to the court, claiming that we had never responded to them. This happens quite frequently. It's astonishing, it's poor behavior, and unfortunately, it's increasingly common. Maybe our professional practice should include being timely, attentive, paying attention to cases, caring about cases, because the more you care about a case, perhaps the less of a cost to your client.